Hi there, folks. This is Sam Price with Probate Notes, and welcome to another episode. I have with me today my very good friend, Paul Shakarian with DLRbond.com. Thanks for being with me here today, Paul.
Hey, Sam, thanks for having me on your Probate Notes podcast. I'm really looking forward to our discussion today. I'm really looking forward to this. You've been asking me to be here on your podcast for a while now, and I want to share with your audience my knowledge on probate bonds.
Thanks. I love that because that's something that everyone has to deal with. First off, I kind of want to get a little bit about your background. Can you tell us? I know you're an attorney, but tell us all about it.
Oh, okay. Yeah, Sam, I'm an attorney. I was licensed back in 2001 and practiced law for many years. And about 10 years ago, I got into doing probate bonds. And it's a really interesting story about how I got into it. And it was mainly by accident. My father was an insurance broker, and unfortunately he had an accident and I had to take over his book of business. And I had no intention of running it. I was just going to wind it down because I was busy with my practice. But when I took it over, um, many of my colleagues in the legal profession found out I was doing this, and they were asking me about probate bonds because they were having trouble with getting bonded sometimes. So I looked into it, and um, I started providing these bonds to my colleagues, and I decided to go in that direction, and I quit practicing law. And for many years now, um, we do all types of surety bonds at this agency, not just probate bonds, any type of license and permit bond. Um, we have our website, DLR Bond, where you can download the application. And I'm really happy doing this because I'm providing a really good service to the legal community. Um, they're really happy with the responsiveness that, we're providing to the law firms. You know, there's, um, we have a sense of urgency here to respond as quickly as possible when bond applications come in, and, um, we'll get into this further on in our interview, but we have some, features that we provide that I think, provide um, a better choice or a different, you don't have to be locked into one provider. There's other choices out there, and you might be happily surprised if you try our agency. Okay.
Paul, can you tell us what is a surety bond?
Yeah, Sam, thanks for that question. A surety bond, I mean, it when you break it down in a simple definition, it's a promise, okay? A surety bond, it's a written promise to be liable for a debt, default, or failure of another. It's an agreement providing for monetary compensation should there be a failure to perform specified acts within a specified period. Okay, so that's the legal definition. But in layman's terms, because nobody likes hearing lawyer jargon, the best way I can explain it is, as a surety, we promise that someone else will keep their promise. And if they don't keep their promise, we promise to keep their promise. And
Okay,
that's the best way I can explain it.
so if somehow the assets or the money of the estate are mishandled, then the surety bond is there to be able to make the estate whole.
Yes, it's going to protect the other heirs and the creditors. And often in an estate, um, as you know, practicing probate law, the administrator has a duty to perform their duties in a proper manner. And if they don't, that surety bond there is to protect those other heirs and the creditors. Um, it's a three-party contract with these Surety bonds, it differs from insurance, because we have 3 parties. We have the insured, and in the bond business, we call them the principal. On your end of it, we call them the administrator of the estate.
Okay.
Well, that's a first party. We've got the surety company who guarantees the performance. And then there's a third party, which we have this Latin term. It's called an obligee. And it's a Latin term meaning to put under obligation. And that's the entity requiring the bond, which is typically the probate court. So we have 3 parties.
Okay. So the personal representative, the court, and the surety company.
Correct.
And so with this three-party agreement, it's that the estate actually is not a party to, I guess, through the personal representative.
Yes.
Okay.
Um, and you know, this a lot one of the big questions that I'll get from applicants and attorneys is there's a lot of confusion because they think a surety bond's an insurance policy, and it's not. It differs from insurance in many ways.
Bottom line, pay the premiums. You know what else I see happen, Paul, is sometimes, for example, I'll get a client appointed on a special administration and they have to serve with bond.
Yes.
But then later they get the general administration. So they get full letters of
Yeah.
administration. Do I have to get a whole new bond, or is there some way that the first bond we got, because we've already paid an annual premium. So if we get a whole nother bond, now the whole nother premium is due. Is there a way to change or amend the bond?
Oh, that's an awesome question, Sam. And for your listeners at home, this is what's called a bond rider. Okay. So like you said, once we have a special administrator appointed, and then later on they're appointed as regular administrator, we're gonna just forward me the order showing that they now have the appointment as administrator, and then we'll contact the surety and order what's called a bond rider. This is not a new bond. This is a document that will be filed with the court that amends the existing bond. There's no additional premium for this unless we're increasing the bond amount, because sometimes that does happen, right? So let's say when they're appointed special, they're at 75,000, and then once they get appointed general, the judge decides to raise it up to a higher amount. Well, then there would be a difference in premium that they'd have to pay for that change. But if it's the same bond amount straight across, there won't be any additional premium.
Can we talk a little bit about how do we exonerate the bond?
Okay, so this is going to happen when the case is concluded, right? So um, you're going to once the final accounting's done, all of the final documents have been filed with the court. There's going to be what's called an ex parte petition for final discharge and order. That needs to be signed by the judge. You provide it to me or whatever surety company you guys are working with, and we'll send that to underwriting and put a request in to cancel, or what we call exonerate, the bond. Because remember, that surety company, they're on the hook with the court for that bond until that document's been signed by the judge. So as soon as we provide that to the surety company, they'll exonerate the bond in their system, and then the client will no longer be responsible for any future premiums on that bond. And then that's when, at which time, if we're in the second year, there will be a calculation of any unearned premiums refunded back to them. Now, sometimes we'll have a client that doesn't pay the renewal premium, right? Um, and then we have the ex parte petition for final discharge and order provided to us. We're still going to exonerate that bond, but they're not going to get a refund of unearned premium because they didn't pay the renewal premium. And technically, they're still responsible for that premium that was due while the bond was in force.